Okay, for the sake of my students and those who would like to review for bar examination, I have decided to upload my lecture in labor law review. In my review, I'm going to teach you the basic labor law standards and labor law relations. And then I'll teach you what are the important subject matters to be focused on with the students, and I will just follow the way how I present the topics in my book. So I will not be discussing labor code according to articles. So I will discuss labor law. First, I will focus on labor standards, and then I will attach and add social legislations. So I'm thinking that in every 2 or 3 topics will comprise one video clip, and I will upload in YouTube so everybody can watch for free. And taking into consideration the predicament this pandemic, where online classes are now the mode of or the manner of conducting lectures, so I think it is better if I record my lecture for the sake of students who don't have good internet signal. So the first topic which we are going to discuss would be the nature of labor laws. In previous bar examinations, the preliminary questions in labor would be define social legislation or social legislations. What do you mean by a social legislation? And the next question would be, would you consider labor law social legislation? So first we will discuss the nature of social legislation so that you will understand, because this is a good source of question in bar exam. When you talk of a social legislation, we are talking here of a law, and the law enacted by the state in the exercise of its police power for the purpose of protecting or giving benefits to a particular segment in society. And these particular segments of society are usually the underprivileged, the poor, the underrepresented, with the objective of promoting social justice. So if you dissect the definition of a social legislation, you have to start with the basic concept first. One, it is a law. It is enacted by the state in the exercise of its police power. You will recall in your constitutional law 2 that the state has 3 inherent powers. You have the police power, the power of eminent domain, and taxation. Social legislations are enacted based on police power of the state, because the police power, the object of police power is general welfare. And if you want to protect and promote the rights of a particular group or segment in our society, then you are promoting general welfare. In fact, the principle of social justice is not contradictory to the concept of general welfare. If you promote general welfare, then you promote if you promote social justice, then you promote general welfare. So that's why you have examples of a social legislation. You have your Comprehensive Agrarian Reform Law, you have your SSS law, JSIS law, PhilHealth, Pag-ibig, etc. So when you will be asked in bar examination, that's how you will answer it. Look at the aspects of my definition. And to summarize this concept, just remember the slogan of former President Ramon Magsaysay in the 1950s. According to President Magsaysay, those who have less in life should have more in law. Well, he is practically correct, because social legislation is a law giving more to those who have less in life. I usually use the fulcrum as a model, no, in our society. So before I go to the next topic, I want you to remember a fulcrum. On the other end of the fulcrum are the rich and the powerful. On the other end also you have the underprivileged, the oppressed, the underrepresented groups of people. The fulcrum tilts in favor of the employer, or the rich. So the state has to enact social legislations in order to add more weight to the other end of the fulcrum, in order to more or less reach the balance of the fulcrum. Of course, it is very ideal when it's very ideal to attain the balance, because we are still in search for what is ideal in our society. So, but we can approximate social justice. More or less, we can bring the fulcrum to closer to perfect balance. So that is our objective. So it's very easy using this analogy. Social legislations are like additions to, or weights, no, added to the other side of the fulcrum. So that's how you will remember it. So if you will be asked, define social legislation, so just add those elements, make your own definition, then you will get it. The next question would be, would you consider labor laws as social legislations? Then the answer would be yes, because labor laws are giving more rights, protection, benefits to workers vis-a-vis the powerful employers. And you will be asked, what are the kinds of labor legislations or labor laws? That's how we group our study in College of Law. You have the labor standard and you have your labor relations law. If you'll be asked in a bar examination, you define labor standard, all you need to remember is that the analogy of one-way traffic. The labor standard set out the minimum terms, conditions, and benefits of employment that the employer must provide or comply, and the employees are entitled as a matter of right. So when you're talking of labor standard, you're talking here of the obligations of the employer to the employee. These are demandable obligations that if the employer will not comply, there will be liability. So it's like employer giving to the employees, and the employees in return are not required by law to give anything. So that is labor standards. The reason why these laws are created, because if you look at the relationship between workers and the employer is so powerful. The employer has everything: money, connection, influence, property, while the worker only has labor vis-a-vis the mighty employer. So the state has to come up with labor standards or laws setting out the minimum, because if you don't set the minimum, logically the employers will not give benefits due to the employees. Remember, the objective of the employer is to maximize profit. And you know, in our study of economics, that in order to maximize profit, you have to minimize expenses. Labor expense is one of them. So the employer will usually minimize the expenses by not paying the minimum wage, by not giving benefits to employees. So that is the purpose why labor standard is created. On the other hand, when you talk of labor relations law, we are talking here of set of laws defining the interaction or regulating the interaction between the employer and the employee. Why would the employer and employee interact? So they interact because the employee will demand higher benefits than what the law provides. So how will they interact? What is recognized under the law as a means of interaction would be the collective bargaining negotiation as a process. So the employer and the employee will sit down and negotiate. The employer will demand. Unfortunately, the employer will refuse. So if the employer will refuse, then the employee will use the tool or the instrument of peaceful concerted activity. And one of that is strike in order to compel the employer. So in labor relations, the idea of labor relations is that both parties are active. The workers interacting with the employer, demanding additional benefits, and the employer will usually refuse. So there is an active interaction. It's like a two-way traffic where both parties interact, and their interaction is done through the process of collective bargaining negotiation using the representatives. So that's how to distinguish labor standards from labor relation. All you need to do is just understand and use your own words in order to get the definition. Regarding social justice, I cited in my book the landmark case of Kalalang versus Williams. So you will understand what is the essence of social justice. According to that case, social justice means the promotion of the welfare of all people, the adoption by the government of measures calculated to ensure economic stability of all component elements of society through the maintenance of a proper economic and social equilibrium in the interrelations of the members of the community constitutionally through adoption of measures legally justifiable or extra-constitutionally through the exercise of powers underlying the existence of all governments in the time-honored principle of salus populi is supreme lex, which means that the welfare of the people is the supreme law. So when you enact social legislation, since you will promote social justice, the basis of enactment of the law is the welfare of the people. And since it is considered as the supreme law in our democratic society, so that's the essence. However, you have to remember that, social justice cannot be abused by the oppressed just because laws are created and giving them favor. Social justice cannot be used, of course, to justify a wrongdoing simply because the worker is at fault, and therefore the worker cannot be terminated. That is also wrong, because that is not the essence of social justice. You cannot use this principle in order to conceal or hide a wrongdoing. So if the employee is or has committed serious misconduct or any of the grounds or just causes for termination, the employee cannot say that I cannot be terminated based on the principle of social justice. That is wrong. To say the least, social justice can be used to mitigate the penalty, but not condone the offense. So that's why the ruling of the Supreme Court, being compassionate and in harmony with social justice, the Supreme Court ruled that termination is the last recourse. If you can suspend an employee, do not impose the maximum penalty of termination even if the employee is at fault. That ruling of the Supreme Court is in line of the principle of social justice. So you can take note of the case of Francisco Duque versus Florentino Veloso, June 19, 2012. That case will tell you that social justice cannot be used or cannot be abused by the workers also. Okay, since we are talking of a social legislation, so you know already what is the nature of this law. A social legislation favors a particular class. In other words, there is what we call a bias of the law, social legislation. Especially we are talking now of labor laws. The next question in the bar examination is that the bar candidates were asked to define or explain the liberal construction of labor standards or liberal interpretation of labor standards. What do you mean by that? Actually, that question revolves around Article 4 of the Labor Code, which means that according to Article 4, all doubts in the implementation and interpretation of the provisions of the Labor Code, including its implementing rules and regulations, shall be resolved in favor of the worker. So, being a social legislation, Article 4 is like our guide. It's like a compass. This will tell us on how are we going to decide as to how the Labor Code and its implementing rules will be interpreted. Article 4 starts with the phrase, all doubts. Meaning, Article 4, the bias of Article 4 will only apply if there is a doubt. When can we say there is doubt? As law students, you know, laws are not perfect. There are gray areas. There are several interpretations. So these gray areas will create doubt on the part of the labor arbiter in this case. So if the labor arbiter is not sure as to the interpretation of the labor code or its implementing rules involved in a particular case, then it will be resolved in favor of the worker. Now, Article 4 has been expanded by the Supreme Court because the Supreme Court, in its experience of all the cases that reached before them, doubts revolve not only in the interpretation of the provision of the Labor Code and its implementing rules. Doubts can also arise in the interpretation of contracts. So the Supreme Court expanded that Article 4 will also apply in the interpretation of contracts or agreements, as well as to interpretation of evidence. You have your Aconia versus Court of Appeals. Then you have all succeeding cases telling you that if there is doubt as to interpretation of contract, labor contracts more particularly, they resolve that in favor of the worker. Also with evidence, you recall your rule on, or the equipoise rule in criminal law, in political law, you encounter the principle equipoise rule. That equipoise rule also applies in labor law. That's the case of Cocoa Plants Incorporated et al. Versus Villapando, May 30, 2016. According to Supreme Court, this equipoise rule applies if there is doubt as to appreciation of evidence. So if you will be asked in your bar examination regarding the liberal construction or interpretation of the labor code, you include that in case of doubt as to the interpretation of the labor code and its implementing rules, including evidence and contracts, you will resolve in favor of the worker. So you will have a complete definition. Because if you will only state that the coverage of Article 4 will only be doubts as to the interpretation and implementation of the labor code and its implementing rules, then that would not be complete. So you have to impress the bar examiner. So you answer it that way. That's the liberal construction. However, it would seem that Article 4 is biased. It gives favor to the employer. According to Supreme Court, this Article 4 cannot also be used to oppress the employer, because take note, Article 4 only applies if there is doubt. So if there is no doubt, then the law itself will be interpreted as it is. So if the employer is in good faith and following the law, then the employer will win. So Supreme Court also respects the right of the employer. So if you will be asked in your bar examination, is Article 4 anti-employer? The answer is no. It is not, of course, anti-employer. Because not in all instances that it will be resolved in favor of the employer. Only when there is doubt. And I already explained why when it is resolved in favor of the worker if there is doubt. Because we are talking here of social legislation. There will be so much injustice if there is doubt and you resolve in favor of the employer. That's too much. However, if there is doubt and you resolve in favor of the employee, then it's okay because this is, after all, a social legislation. So, if there is any question in the bar examination regarding preliminaries, one of the sources of question would be this, social legislation, the scope of Article 4, the liberal interpretation of the labor code. And of course, other questions as preliminaries would be the constitutional basis of the right to self-organization or the rights of employees guaranteed by the Constitution to self-organization. We will discuss that in the topic on labor relations. So I hope that if there is any question in your bar examination involving those topics, you can answer. So for better guidance, you can secure a copy of my book in labor standards and social legislation, lecture notes and cases. It's with Rex Bookstore. I hope that topic is clear because the next topic would be management prerogative. So that you will understand the essence or the bottom line of the dispute or the clash between workers and employer is this, the management prerogative exercised by the employer and the rights of workers. When they interact, they often collide and end up in clashes. All labor disputes are examples of the clashes between management prerogative and the rights of workers, especially security of tenure. So what is this management prerogative? When a company is created after being registered with the Securities and Exchange Commission, the company will put up its physical structure, buildings, equipment, etc. Once the company has constructed and is ready to operate, its management prerogatives will also, shall we say, emerge, because I describe it as inherent right of companies. So once they are registered and they're beginning to operate, then these management prerogatives will be available at hand. These are inherent rights. There are only few provisions in the labor code stating management prerogatives. To name a few, you have your prerogative to terminate employees based on just or authorized causes, and then the implementing rules on the right of management to suspend employees or place the employee under preventive suspension. So basically, management prerogatives are expression of the proprietary rights of management. If you look at management prerogatives, it will show you the scope of the exercise of this right. It includes hiring, work assignments, work method, the time and place and manner of work, the tools to be used, etc. All of these are descriptions of management because the management is the owner. So it is a right protected under the Constitution, the right of property. Section 1, Article 3 of your Constitution will tell you that no person shall be deprived of life, liberty, or property without due process of law. So the law will not take away your property. This management prerogative is also a property right. It is respected. Okay, so since I mentioned earlier, I have not encountered of a bar examination asking for management prerogative because I do not know, maybe it's not a good source of question. But when you are talking of labor, you don't have to discuss management prerogatives also because this is more on the side of the employer. Okay, so the relevance of management prerogatives will only apply when you talk of termination of employment, because there will be clashes on the right of management to terminate, at the same time the right of employee to security of tenure. So since this is a right, the management prerogative is a right, just like all other rights, it's not absolute. It is limited by law, regulated by law. So generally, the exercise of management prerogative will not be interfered by the court if it is exercised in good faith, if it is done legally, and Article 4 will not apply. So if that's the case, then there's a bigger chance that management prerogative, the exercise of management prerogative will be upheld in the labor court. So just to give you an idea, that's how management prerogatives should be exercised. However, I would like to emphasize that there are limitations also. And the limitations on the exercise of management prerogative, I group them into two. You have the general limitations, then you also have your specific limitation. Now, what are these general limitations? I enumerated the following. You have the 1987 Constitution, which emphasizes due process and social justice clause. You cannot terminate an employee without due process. So when the management exercises its prerogative to terminate employee, the Constitution imposes a limit. You exercise due process, meaning you give the employee the notice to explain, and you give also the succeeding notice of termination. Then, of course, the social justice clause, because that's where you can find the rights of employees to security of tenure, etc. Then you also have your labor relations law, especially the exercise of the right to terminate employees. The labor relations law will set the limit. That's why it enumerated just or authorized causes as the grounds to terminate employees. You also have contracts. If the employer will enter into contracts with employees, like labor employment contract, and more specifically collective bargaining agreements, then these contracts will become limitation to the exercise of management prerogatives. Company policies, these are, I describe it as self-imposed limitation by the employer, because the employer will come up with its own policies limiting the exercise of its prerogative. There is no prohibition if the employer will impose its exercise of, like for example, promotion or demotion. The employer can set a limitation, self-imposed limitation. The other one is you have our commitments, because we are a signatory to the International Labor Organization, the ILO conventions. Under the principle of doctrine of incorporation, if there is an agreement by the ILO, they become part of the law of the land. So, since we observe generally accepted principles of international law as part of the law of the land, and compliance to treaty under the principle of pacta sunt servanda is a generally accepted principle of international law, then conventions will become law of the land. And if there's any limitation there in the convention and the exercise of management prerogative, then it will become a limitation. You also have company past practices that have ripened into a benefit. So that will limit also. Example, bonus is not mandatory. However, the company made it a past practice and it has ripened into a benefit. With that, the company cannot say, I will exercise my management prerogative and withdraw this bonus I gave to my employees for several years. You cannot do that because it has become a company practice. And lastly, you have the principle of general principles of fair play and justice. The last among all. If all of the above will not apply, remember there is the principle of fair play and justice. The exercise of right reasoning, confronting with the situation, the decision of management cannot also be done against the right reasoning. Then regarding the specific limitation of the management prerogative to hire, this is how I start with the specific laws on the right of management to hire. So once the company is created, you have now your equipments, etc. The company cannot operate without employees. You have to hire employees. Now, regarding the hiring, the common question of bar examination would be on the criterion of age. So, of course, there will always be a question in the bar examination on the hiring of minor. How are we going to deal about it in the hiring of minor? So first, you start with the rule under RA 7610 that, children below 15 years of age shall not be employed because 7610 has been amended by 7658. That is the general rule. If you will be asked in your bar examination, what is the minimum employable age? Of course, the answer is 15 years. If you will be asked, can you hire a minor below 15? The general rule, it's not allowed. It's prohibited. Under Section 12 of RA 7610 as amended by RA 7658. The objective of this rule or law is to protect children from abuse and exploitation, to keep them in the home and school for their proper development, subject of course to certain exceptions. So there are so many limitations when you hire a minor below 15. So that is the first group. I observed that most of the questions asked regarding hiring of minor is between 15 years old and below 18, because that's where you can find so many discussions also. But for purposes of bar examination, let's look at hiring of minors below 15. What are the instances? First, when the minor works under the sole responsibility of the parents or guardian. However, there is the requirement that only immediate members of the family are employed, and the employment neither endangers his life, safety, health, and morals, nor impair his normal development. And finally, the parent of the legal guardian shall provide the minor with the prescribed primary and or secondary education. So that's the first scenario when a minor works, below 15-year-old minor works under the sole responsibility of parents. This is common in our society, especially in a small store run by the family, sari-sari store. So that is the requirement. The other scenario is when the minor is employed outside the responsibility of the parents or the guardian. We are talking here of child's employment, participation in public entertainment or information through cinema, theater, radio, television. So when you employ a minor here, you have to comply with the requirements. Contracts signed by the parents, and if the minor is possible, then there will be permit from the Department of Labor. So that is very important. Section 12, Article 8 of 7610 as amended by 7658. So you need permit. For purposes of the requirements of permit, you have your Department Circular number 2, series of 2018. When permit is required, it also provides when permit is not required. The question in the bar examination will not be the details on the requirements of the permit. So if you'll be confronted of hiring a 10-year-old in order to perform in cinema, then you focus on the contract and the permits issued by the Department of Labor, and you will ensure that the child will not be exposed to hazardous activities, and the child's development is ensured. Another thing is, for a child below 15, you have to emphasize also the hours of work. A child below 15 years of age must be allowed to work for not more than 20 hours a week, provided that the work shall not be more than 4 hours at any given day. That's below 15. And no child below 15 years of age shall be allowed to work between 8 o'clock in the evening and 6 o'clock in the morning. That is another limitation that you have to consider. So that's what we are talking here of the limitations as to the hiring of minors below 15 years of age. So we are talking here of 14 years old and below. So general rule, you cannot employ, subject to the following exceptions which we discussed. Of course, there is also that absolute limitation. Remember that the child shall not be used to advertise alcoholic beverages, cigarettes, and any form or expression of vices. That's not allowed. That's absolute. What about minors 15 years old but below 18? First, when you talk of minors 15 years old and below 18, you can employ because the minimum employable age is 15. First, I would like to emphasize that you can hire 15 years old as domestic worker. Below 15, it is really absolutely prohibited under RA 10361, the Sambahay law. So when you hire a worker who is below 15 years old as a domestic worker, you have to comply many things. First, you have Section 10A of the Public Act 7610, that this child shall be subject to child abuse, cruelty, exploitation, etc. Another limitation also under the Sambahay law is the second paragraph of Section 12A of RA 7610 as amended by 9231. The hours of work. A child 15 years old but below 18 shall not be allowed to work for more than 8 hours a day, and no case exceed beyond 40 hours. So if you will be asked in your bar examination as to the hiring of a domestic worker who is 15 years old or 16 years old, in addition to those prevention against abuse, remember also the working hours. It should not exceed 8 hours a day. Then you also have another limitation when you hire a domestic worker under paragraph 4, section 12D of R 7610. it should not be hazardous. Then you also have your Section 13 of Republic Act 7610 as amended by 9231. It provides that no child shall be deprived of formal or non-formal education. In all cases, the employment is allowed in this act. The employer shall provide the working child with access to at least primary and secondary education. So when you hire a domestic worker who is 15 years old or below 18, in addition to the limitations I discussed above, then you have to provide primary and secondary. So you have to provide two, primary and secondary. Then of course, the working child who is 15 years old or 16 years old or below 18 should be entitled to the minimum wage of house helpers or the domestic workers. So outside those domestic workers, children 15 years old but below 18 shall not be allowed to work more than 8 hours a day, not more than 40 hours a week. And working hours of the day, they should not be allowed to work between 10 o'clock in the evening until 6 o'clock in the morning. Subject, of course, to exception that under Article 59 of the Labor Code, you can hire apprentices who are at least 15 years of age. Then you can also hire student workers. Then you also have to remember also that when you hire student worker under RA 7323 as amended by the RA 9547, the age there provides that at least 15 years old but not more than 30 years old. So you can hire a student worker who is 16 years old, 17 years old and above. So those are the exceptions where you can hire (15 years old but below 18). Take note of the limitations, because when you hire these persons 15 years old and below 18, the law on hazardous environment or hazardous undertaking also applies. So you cannot make an employee who is 16 years old perform hazardous activities. Now, in order to understand the subtopic in hiring of minors would be the common limitations, no, when you hire persons below 18. So what are these common limitations? One, when it comes to wages under Section 12B of RA 9231. The wages, salaries, and earnings of the working child shall belong to him, and not more than 20% of the child's income shall be used for the collective needs of the family. Paragraph B, the income of the working child and the property acquired through the work of the child shall be administered by both parents. In the absence or incapacity of either of the parents, the other parent shall administer the same. Paragraph C, the parent or legal guardian of the working child below 18 shall set up a trust fund of at least 30% of the earnings of the child, whose wages and salaries from work and other income amounts to at least 200,000 pesos annually. And in fact, they are required to render accounting to the DOLE under Section 12B of RA 9231. So that's limitation when it comes to income. This applies to hiring of minors below 18. Let's look at the absolute limitations applicable to hiring of minors below 18. One would be the worst forms of child labor. So regardless of age, as long as below 18, you cannot employ a child in any form of worst child labor, in the worst forms of child labor. What are these? Of course, enumerated under Anti-Trafficking Act: exposing child to prostitution, for illegal activities, etc. So that's your limitation. That applies to all. Another limitation would be now outlined in Department Order number 149 series of 2016, the hazardous occupations. So even if the minor or the employee is 17 years old, you cannot make the employee work in an hazardous activities. So under Department Order 174 series of 2016, these hazardous activities are grouped into three: industrial classification, occupational classification, and another classification as provided for by law. So it used to be before, the different hazardous activities were outlined. Now they are simplified and grouped into three. When you talk of industrial hazards, industrial occupations, we are talking here of mining and quarrying, construction, transporting and storage, water supply, sewerage, waste management and remediation activities, forestry, logging, fishing and aquaculture, hunting, trapping and related activities, security investigation, manufacturing of alcohol beverages, alcoholic beverages, tobacco, pyrotechnics, rubber, plastic products, chemicals and chemical products, basic metals and weapons and ammunition. So these are industrial hazards. So you cannot make the minor work in any of those. On the other hand, you have your occupational hazards. Farmers and other plant growers. You cannot hire minors below 18 to work in the farm. Animal producers, then physical science, life science and health associate professionals, sales and service elementary occupation, personal protective service workers, customer service clerks, other crafts and trade and related trade activities. So this classification of hazards, industrial and occupational, this applies to all minors hired below 18. Then remember the absolute prohibition I mentioned earlier under kasambahay law. It is absolutely prohibited to hire as kasambahay a minor below 15. Then you also have the absolute prohibitions on advertisement, promoting alcoholic beverages, intoxicating drinks, tobacco, its byproducts, gambling, or any form of violence or pornography. So as you can see, when you will be asked of the hiring of minor below 18, I observed that the favorite question would be hiring below 18 but not below 15. So remember the limitations. The rule is you can hire. So if you will be asked, can you hire a minor who is below 18 but not below 15? The answer is yes, because the minimum employable age is 15. However, you enumerate the limitations as I discussed a while ago. It's very easy. There are only two sources of questions in bar examination regarding hiring of minor. One is when you hire minor who is 15 years old but below 18. General rule, you can hire, then enumerate the exceptions or the prohibitions or the qualifications. You have so many: working hours, income, worst form of child labor, etc. Then you also have the hiring of minor below 15 under two conditions: under the sole responsibility of parents or in public entertainment. That's how you summarize. You can now answer questions regarding hiring of minors. So that's how I presented my topic when you talk of hiring of minors, because that is the favorite question in bar examination. Just remember the absolute prohibitions is either you will be asked of a hypothetical situation of a domestic worker who is 14 years old, and the hiring of minor is below 18 but not below 15. Rest assured, the most common source of bar question when it comes to hiring of minor is below 18 but not below 15. And usually the questions were centered on either worst form of child labor or hazardous occupation. So with that, I hope that I have clarified to you the limitation on management prerogative to hire as regards age. The next limitation as regards hiring, we are now talking here of above 18 years old and above. We are now talking of the stipulation against marriage, because this is another limitation of the management prerogative to hire. Under Article 134 of the Family Code, Labor Code, it is declared prohibited or unlawful for an employer to require as a condition that a woman should not get married, or even stipulate that upon getting married, the woman is deemed resigned or terminated, or being prejudiced by reason of marriage. That is not allowed. That's why it is called stipulation against marriage. So you cannot hire an employee and make the employee promise not to get married. It violates the right of equal protection. The law recognizes the equal protection between women and men under Section 9, Article 2 of the 1973 Constitution and Section 14, Article 2 of the 1987 Constitution. The right to marry is also a constitutionally guaranteed right, because marriage is the foundation of the family and it is protected by law under Section 2, Article 15 of the 1987 Constitution. So you violate that constitutional mandate. However, there is an exception when a company prohibits you from marrying a particular employee of the competitor in order to protect its trade secrets and procedures. That is allowed according to the Supreme Court. Then another limitation, the exercise of management prerogative to hire, would be night work prohibition, especially assigning employees to work at night between 10 o'clock in the evening and 6 o'clock in the morning. They are called the night workers under DO 119-12, Section 2. So you cannot hire an employee and put the employee in the schedule between 10 o'clock in the evening and 6 o'clock in the following day if the employee is not fit to work. That's why there is the right of the employee to undergo health assessment. So it is considered a limitation, because if the employee is not fit to work at night, then you cannot dictate that you will hire the employee and make the employee work at night. So it limits the exercise of management prerogative to hire, because the law dictates that employees who are not fit to work at night cannot be compelled to work as a night worker. In fact, when those employees are already working and then due to health condition, after health assessment, then they can be transferred to daytime work. So that's the night work prohibition. Another limitation in the exercise of management prerogative is hiring of qualified employee with disability under RA 7277. This has been amended by RA 10524. Section 5 of this RA 10524 provides the prohibition that no person with disability shall be denied access to opportunities for suitable employment. A qualified employee with disability shall be subject to the same terms and conditions of employment and the same compensation, privileges, benefits, fringe benefits, incentives, or allowances as a qualified able-bodied person. In fact, there is a criminal liability if you discriminate or refuse a person with disability who is qualified, of course. With the amendment, with the new law amending the Magna Carta for disabled workers, there is now the requirement of 1% of all positions in the government, offices, or corporation which shall be reserved to persons with disability. However, in the private corporation, it's not mandatory, it's only encouraged. Another limitation in the exercise of management prerogative is the yellow dog contract. This is under Article 259B, where the employer here is afraid that the employee will join union. So the employer will make the employee promise that he will not join a union, and whenever he will join a union, he will quit his employment, and even required during hiring that the employee is not a member of the union. Article 135, 259, Article 259 of this Labor Code paragraph B clearly violates the right of the employees to self-organization and as defined under the Labor Code. It is an unfair labor practice. Another limitation to the exercise of management prerogative is the Anti-Trafficking Act of 2003, RA 9208, as amended by RA 10364, where you cannot hire a person and for purposes of prostitution, pornography, or sexual exploitation. This is the anti-trafficking law. Another limitation in the hiring of employees who are 18 years old and above would be the Anti-Sexual Harassment Act of 1995. It is declared illegal here when you ask sexual favor and make that as a condition in hiring the employee. So that is considered crime. So there will be criminal liability if the employer will do that. So you know what is sexual favor? It redounds to sexual gratification of the person who has power or dominance over the other party. But it is made as a condition for hiring. That's what makes it prohibited. Now the last limitation, that's not yet the last, I think we still have the anti-age discrimination law when you make age qualification as a requirement. subject of course to limitation when it is really necessary in the conduct of the work, and you have to report that to the nearest office of the Department of Labor, because it will create a presumption that the age limitation is in accordance with the rules. This is the anti-age discrimination law. So if you are going to put the age bracket, make sure that there is a reasonable or logical reason, or the nature of the work requires that particular age bracket. Otherwise, do not put in age. So if you require a secretary, do not put at least 18 years old and not more than 25 years old, because any person who is below 60 years old can do the job of a secretary. Another, or the last limitation, is RA 11166, or the law which repealed the Philippine AIDS Prevention Control Act of 1998. This is known as the Act Strengthening the Philippine Comprehensive Policy on Human Immunovirus and Acquired Immune Deficiency Syndrome, AIDS prevention, treatment, care, and support, and reconstituting the Philippine National AIDS Council. Now, why is this considered limitation? Because it is declared as a discriminatory act under Section 49. The rejection of job application, termination of employment, and other discriminatory policies in hiring, provisions of employment and other related benefit, promotion or assignment of an individual solely or partially on the basis of actual, perceived, or suspected HIV status of the applicant. You mean actual, the job applicant is really sick, perceived, or suspected HIV status, that is not a ground to refuse employment, and there is a criminal liability. Okay, I think that would be the end for this lecture. In the next topic, or next meeting, or next clip, I suppose, we will discuss the other prerogative of management. We will just stop here, no, regarding the management prerogative to hire. And I hope that I am understood, although the most popular source of questions in the bar examination on management prerogative to hire would be the hiring of minors, then seconded by stipulation against marriage. With that, I hope that you can answer any questions based on the topic, and I'll see you in the next lecture. That's all for today.